The blue and red lights flashing in your rearview mirror are not just a signal to pull over. They are the opening move in a high-stakes psychological game where the odds are stacked heavily against you. Most drivers believe that if they have done nothing wrong, they have nothing to worry about. This is a dangerous illusion. The reality is that once those lights hit your windshield, you are no longer just a citizen going home. You are a suspect in an investigation that has already begun, even before the officer steps out of their patrol car. The conversation you are about to have will determine whether you go home to your family or spend the night in a cold cell, facing thousands of dollars in fines, the loss of your license, and a permanent mark on your record that can haunt your career for decades. What makes this situation so terrifying is not the law itself, but the subtle, calculated techniques used to bypass your rights without you even realizing it. These are not random questions. They are traps designed to extract evidence from you while you are confused, nervous, and unaware of the legal boundaries. By the time most people understand what has happened, it is already too late. The damage is done. The evidence is recorded. And the judge will not care that you did not know you were walking into a trap. Understanding these tactics is not about being difficult or disrespectful. It is about survival. It is about protecting your freedom, your livelihood, and your future from a system that relies on your ignorance. You need to know exactly what is coming so that you can remain calm, stay silent, and keep your hands on the wheel. This knowledge is your only shield. The first trick is perhaps the most common and the most deceptive. It happens within seconds of the officer approaching your window. The officer will ask you a question that seems harmless, friendly, and routine. They might say, "Do you know why I pulled you over?" Or they might ask, "Have you been drinking tonight?" On the surface, these appear to be simple inquiries, but legally they are minefields. When an officer asks if you know why they stopped you, they are not looking for honesty. They are looking for an admission of guilt. If you say, "Yes, I was speeding," you have just confessed to a crime. Even if you were only slightly over the limit, that confession gives them probable cause to continue the investigation. If you say, "No, I don't know," they may use your confusion or hesitation as a sign of impairment. The same applies to the question about alcohol. This is not a casual chat. It is an interrogation. The officer is trained to look for specific signs in your answer. They are listening for slurred speech, smelling for alcohol on your breath, and watching for bloodshot eyes. But more importantly, they are recording your verbal response. If you admit to having even one beer, you have given them the justification they need to escalate the stop. They can now claim they have reasonable suspicion that you are driving under the influence. This allows them to ask you to step out of the vehicle, perform field sobriety tests, and potentially arrest you. Mistake almost everyone makes is trying to be polite and cooperative by answering these questions directly. They think that honesty will help them. In reality, honesty is being used as a weapon against them. The safest response is to politely decline to answer. You can say, "Officer, I prefer not to answer any questions." This is your constitutional right. You are not required to incriminate yourself. By staying silent, you deny them the evidence they are hunting for. It feels awkward. It feels rude. But it is the single most effective way to protect yourself. Remember, anything you say can and will be used against you in a court of law. Do not give them the ammunition they need to build a case. As the interaction continues, the officer will likely attempt to move you out of your car. This is the second major trick, and it is critical to understand why this happens. Officers are trained to get drivers out of the vehicle whenever possible. They will often say, "Step out of the car for a moment," or "I need you to come outside so we can talk safely." Once you are standing on the side of the road, the dynamic changes completely. Inside your car, you are in your private space. You are seated, which makes you appear less threatening and more controlled. Outside, you are exposed. You are standing on uneven ground, often in the dark, with bright lights shining in your face. This environment is designed to disorient you. It makes performing physical tasks much harder. The officer will then ask you to perform field sobriety tests. These tests are not scientific measurements of your intoxication. They are subjective evaluations designed to make you fail. The standard tests include walking in a straight line, standing on one leg, or following a pen with your eyes. These tasks require balance, coordination, and focus. Even a perfectly sober person can fail these tests if they are nervous, tired, wearing uncomfortable shoes, or dealing with medical issues like bad knees or poor vision. The officer is not looking for proof that you are drunk. They are looking for any clue, any stumble, any missed instruction that they can write down in their report as evidence of impairment. What most people do not realize is that in many jurisdictions, you have the right to refuse these field sobriety tests. They are voluntary. They are not mandatory like a breathalyzer test might be in some states after an arrest. By refusing, you deny the officer the visual evidence they need to justify an arrest. Yes, they may still arrest you based on other factors, but you have made their job significantly harder. You have removed the easiest path to a conviction. Refusing these tests is not an admission of guilt. It is a strategic decision to protect your rights. If you feel pressured, remember that you are not obligated to perform acrobatics on the side of a highway to prove your innocence. The burden of proof is on them, not on you. Do not help them build their case against you. If the officer decides to escalate further, they will introduce the third trick, the preliminary breath test. This is different from the chemical test administered at the police station. The preliminary breath test is a handheld device used at the scene. Officers often present this as a quick way to clear things up. They might say, just blow into this so we can see if you're okay, and if you pass, you can go home. This is a lie. The purpose of this test is not to let you go. It is to gather enough evidence to arrest you. In many places, you have the right to refuse this preliminary test without facing the same penalties as refusing a post-arrest chemical test. However, officers rarely explain this distinction. They rely on your fear and confusion to compel compliance. If you blow into the device and it shows any amount of alcohol, even below the legal limit, they can use that result to justify further testing and potential arrest. If you refuse, they may still arrest you based on their observations, but they will lack the concrete number from the roadside test. It is crucial to know the laws in your specific state, but generally, refusing the preliminary roadside test is a smart move. It forces the officer to rely solely on their subjective observations, which are much easier to challenge in court than a numeric blood alcohol reading. Do not be fooled by the promise of a quick release. There is no quick release once the investigation has started. The only way to win is to not play the game. Politely refuse the preliminary breath test. State clearly that you do not consent to any testing. This creates a clear record of your refusal, which can be vital for your defense later. The officer may become angry or threatening. They may imply that refusing will make things worse. Stay calm. Do not argue. Do not explain. Just repeat your refusal. Your silence and your refusal are your strongest allies in this moment. The fourth trick involves the search of your vehicle. Officers often ask for permission to search your car. They might say, "Do you mind if I take a look around?" Or they might imply that if you have nothing to hide, you should let them look. This is a classic manipulation tactic. They are fishing for contraband, open containers of alcohol, or anything else that could lead to additional charges. If you say yes, or if you hesitate, they may interpret that as consent. Once you give consent, they can search your entire vehicle without a warrant. They can tear apart your seats, check your trunk, and go through your bags. If they find anything illegal, even something unrelated to driving, you could face serious criminal charges. The key here is to never consent to a search. You have the Fourth Amendment right to be free from unreasonable searches and seizures. If an officer asks to search your car, you must clearly and firmly state, "I do not consent to any search of my vehicle." Say it loudly enough to be recorded. Say it clearly. Do not be afraid of offending the officer. Your priority is your legal protection, not their feelings. If they proceed to search anyway, do not physically resist. Physical resistance can lead to additional charges and physical harm. Instead, continue to state your non-consent verbally. This creates a record that the search was involuntary, which can help your lawyer get the evidence thrown out in court. Many people waive this right because they feel pressured or because they believe that cooperating will make the officer go away faster. The opposite is true. Cooperation often leads to deeper intrusion. By asserting your right to refuse, you draw a legal boundary that the officer must respect or risk compromising their case. This is not about hiding something. It is about maintaining your constitutional protections. Never let fear or politeness off. Override your rights. A simple phrase, "I do not consent," can be the difference between a minor traffic ticket and a felony charge. The fifth and final trick is the threat of implied consent laws regarding chemical tests. After an arrest, officers will demand that you take a breathalyzer or blood test at the station. They will warn you that refusing will result in an automatic suspension of your driver's license. This is true in many states. Implied consent laws mean that by driving on public roads, you have agreed to submit to chemical testing if arrested for DWI. However, there is a strategic nuance here that many people miss. While refusing the test may lead to a license suspension, it also denies the prosecution the most powerful piece of evidence they have: your blood alcohol concentration. Without a chemical test result, the prosecutor must rely on the officer's testimony and the field sobriety tests, which are much weaker and easier to dispute. In some cases, the penalty for refusing the test is less severe than the penalty for a high blood alcohol reading. For example, a first-time refusal might result in a 6-month license suspension, while a conviction for DWI with a high BAC could result in a year-long suspension, heavy fines, jail time, and a permanent criminal record. You need to weigh these consequences carefully. This is where having a plan beforehand is essential. Know your state's specific laws. Understand the trade-offs. In some situations, refusing the chemical test is the lesser of two evils. It prevents the state from having irrefutable scientific proof of your intoxication. It forces them to build a case on circumstantial evidence, which leaves room for doubt. Doubt is your friend in a criminal trial. Certainty is their friend. By refusing, you introduce uncertainty. You make the case harder to prove. This does not mean you will definitely win, but it gives your defense attorney a fighting chance. Do not make this decision in the heat of the moment. Decide now, while you are calm and rational, what your stance will be. If you choose to refuse, do so clearly and consistently. Do not waver. Do not agree after initially refusing. Stick to your decision. The officer may try to intimidate you with threats of longer suspensions or jail time. Remain steadfast. Your license can be reinstated. A criminal conviction cannot be easily erased. These 5 tricks are not isolated incidents. They are part of a coordinated strategy designed to secure a conviction with minimal effort. The officer's goal is to gather enough evidence to justify an arrest and ensure a successful prosecution. They rely on your fear, your confusion, and your desire to be cooperative. They count on you not knowing your rights. They count on you making mistakes. By understanding these tactics, you take away their advantage. You transform from a passive victim into an informed participant who knows how to protect themselves. This does not mean you should be aggressive or confrontational. Aggression will only escalate the situation and give the officer more reasons to detain you. Instead, be polite, be calm, and be firm. Use short, clear sentences. Do not volunteer information. Do not answer questions. Do not consent to searches. Do not perform field sobriety tests. Refuse the preliminary breath test. Consider refusing the chemical test based on your knowledge of local laws. Keep your hands visible. Move slowly. Follow instructions that do not violate your rights. This approach minimizes the risk of physical harm and maximizes your legal protection. It sends a message that you are aware of your rights and that you will not be bullied into incriminating yourself. It is important to remember that every situation is unique. Laws vary by state and by country. What works in one jurisdiction may not work in another. Therefore, it is essential to educate yourself on the specific laws in your area. Consult with a qualified attorney if you have concerns. But the general principles of remaining silent, refusing consent, and avoiding self-incrimination are universally applicable safeguards. They are the foundation of a strong defense. Do not wait until you are in handcuffs to learn these lessons. Prepare yourself now. Share this information with your family and friends. Talk to your teenage children about what to do if they are ever pulled over. Make sure your spouse understands these risks. This knowledge is a form of insurance. It is a shield that you hope you never need to use, but one that could save your life if you do. The stakes are too high to ignore. A DWI charge can destroy your career, your reputation, and your financial stability. It can affect your ability to travel, to vote, and to own a firearm. It can strain your relationships and cause immense emotional stress. Preventing this outcome starts with how you handle those first few minutes after the lights flash. If you found this information valuable, consider subscribing to this channel. We are dedicated to providing you with the knowledge you need to navigate complex legal and social situations with confidence. Your subscription helps us continue to create content that protects and empowers viewers like you. It is a small action that supports a larger mission of education and awareness. Join our community of informed individuals who refuse to be caught off guard. Together, we can spread the word and help others avoid the pitfalls that trap so many unsuspecting drivers. Your support makes a difference. It allows us to dig deeper into these critical topics and bring you the truths that mainstream sources often overlook. Do not let this information sit idle. Put it to use. Internalize it. Let it guide your actions if you ever find yourself in this precarious position. The emotional toll of a DWI stop is profound. It is a moment of pure vulnerability. You are alone, exposed, and judged by someone who holds significant power over your immediate future. The fear of losing control is overwhelming, but knowledge restores control. When you know what to expect, the fear diminishes. You replace panic with procedure. You replace confusion with clarity. You realize that you have rights, and that those rights are powerful tools if used correctly. The officer is just doing their job, but their job is not to protect your interests. Their job is to enforce the law and gather evidence. Your job is to protect your rights and your future. These two objectives are often in conflict. Recognizing this conflict is the first step toward resolving it in your favor. Do not view the officer as an enemy, but do not view them as a friend either. View them as a professional adversary in a legal process. Treat them with respect, but maintain strict boundaries. This balance is delicate, but it is achievable with practice and preparation. Think about the person you love most. Imagine them being pulled over late at night. Imagine them scared, confused, and making a mistake that costs them their freedom. Now imagine them armed with this knowledge. Imagine them staying calm, staying silent, and protecting their rights. Which scenario do you want for them? This is why sharing this video is so important. You might save someone from a life-altering mistake. You might prevent a tragedy. Send this to your parents. Send it to your siblings. Send it to your friends who drive frequently. Spread this awareness. The more people who know these tricks, the less effective they become. We have the power to change the dynamic by educating ourselves and each other. Do not keep this secret. Knowledge shared is power multiplied. In the end, the goal is not to beat the system. The goal is to survive it with your integrity and your freedom intact. The legal system is complex and often unforgiving. It does not offer second chances easily. Once a mistake is made, it is incredibly difficult to undo. Prevention is always better than cure. And in the context of a DWI stop, prevention means knowing your rights and exercising them wisely. Do not let fear silence your rights. Do not let politeness compromise your future. Stand firm, stay smart, stay safe. The next time you see those lights in your mirror, remember what you have learned. Remember that you are not powerless. Remember that you have a voice, and that voice can say no. That simple word, no, is one of the most powerful words in the English language when it comes to protecting your liberty. Use it. Respect it. And never forget that your freedom is worth fighting for, even in the quiet, tense moments on the side of a dark road. This script has covered the 5 most common tricks used during DWI stops, but the landscape of law enforcement tactics is always evolving. Stay vigilant. Keep learning. Keep questioning. The world is full of hidden dangers, but it is also full of hidden strengths. Your strength lies in your awareness. Cultivate it. Nurture it. Share it. If you believe this content has provided you with value, please take a moment to like this video. It helps the algorithm show this critical information to more people who need it. Your engagement signals to the platform that this topic matters, that it is urgent, and that it deserves attention. By liking, you are not just supporting this channel. You are supporting the dissemination of vital safety information. You are helping to build a safer, more informed community. Thank you for your time, for your attention, and for your commitment to protecting yourself and those you care about. Stay alert, stay informed, and drive safely.